class. And last week, I don't know what happened, but we missed ourselves the first last week. Um, my senior colleague, that is Professor Igebolo Doku, informed us that he had a class with you and he had discussed with you already on the vehicles of doing business, that is sole proprietorship, partnership, incorporation or limited liability companies, incorporation or limited liability companies, a one man incorporated company. He also treated the concept of agency and its relevance to form of doing business, and also discusses the nature of legislation that regulates business activity. So the aspect that we'll be looking at together is law of contracts. That's why I was asking you whether you were seeing the slide. Um, of course, it's important to reiterate that as businessmen, by the nature of your program, is assume that you are always you always had need to deal with or interact with one person or the other, and this is very common, you know, in the day-to-day life activities itself, because in our daily life, way of living, we have cause to interact with one person or the other, in different ways. Now, one thing that is common when you're dealing with another person is that that person must give you consent. So you can't have any transaction with any person except the consent of that person is obtained. So when you force, someone's consent, you all agree that that cannot be a good solution. So a contract, you know, in one word is known as agreement. But of course, when you say that there's agreement, it means that of course the two minds have come together. The two minds have accepted something in common. The two minds have agreed to do something in common. And so, but then if indeed, of course, even those are the streets, even the Danfo, the Okada man, the security men, the Aboki, all of them know that when you say agreement, they understand what it means. But here we are now, we are not looking at law of agreement, we're looking at law of contracts. So that should interest you to pay attention as to why is this so, right? So why is the class governor? Why is your which name are you using on the platform?
Hello, sir. I'm here, sir.
Okay, what's which name is okay? You're using is this Socrates or what?
Yes, sir.
Okay, so ask the host, ask Dr. Ola Bitona to add you as a co-host so that you can also monitor your classmates. And people that don't have the name should change to rename so that we can understand who and who is online. So
Noted, sir.
as I was saying, we're talking about law of if it indeed it just have to do with agreement per se, then you would have what is called law of agreement, which everybody will understand. But then we create law of contracts. So that what I mean is that there's something special about that agreement, which will be known as contracts. So that's just what we're looking at. What is in an agreement that will be called a contract, and if it is not, it will be called an agreement but not contract. Because as we're going to see, for there to be a contract, there must be agreement, but not all agreements are contracts. And then we're dealing with law of contracts. We're saying that contract simply means agreement. So these are things that you need to that we're going to take note of, in this class. And because you know, contract, which I said is agreement. The question one will ask is, as professionals, in your various field, why must you be bothered about contracts? Is we should bother because by nature of masters in business administration, by its nature, business has to do with a situation whereby one or two persons come together to carry on an activity in common, with the aim of making profit. you know and so in a business setting, by its nature, you can't do it alone. You must have cause to deal with somebody. you know so, and of course, businessmen go into agreement on daily basis, either by way of employment, either by way of supply, either by way of consultancy, either by way of hiring, either by way of borrowing, either by way of opening accounts, and all of those things. So there are so many ways, that the businessmen go into agreement on daily basis, or contract on daily basis. It's in view of the importance of agreements to professionals like you that we deem to have this course. Uh, this so now, by the nature of the course, by its nature, it's a very wide, no wide, but it's wide because for undergraduate student, it's taught for a whole year. It's a 1 year course for regular students. And here we are now, just picking. It's just one of the topic within the whole, one of the topic within the course, which is business law. Right? So we're just going to highlight those things that we need to know. So we cannot go in details because of time factor. So we expect you to pay attention to some of all those things that we're going to highlight for your benefits. And of course, in a class like this, I always, because being our first class lectures, I know that you're coming from different backgrounds. For those other people that have interacted with them, we did something which was very interesting, which is to the effect that uh, they all accepted, they all agreed that you know for the purpose of our class, all of you are lawyers. And of course, I was one that did that because legal profession is not just about reading and passing exams. Someone must pronounce on you that you're a lawyer. That's when you become a lawyer. So code to buy is done physically. If you, unlike the normal degree that you can, during convocation, you'll not be there, but you have a certificate. Those lawyer is not like that. You must physically present to the court to bar to become a lawyer. So, and of course, someone will pronounce on you, and then you become a lawyer on that day. So, by the powers conferred on me 19 years ago, as a lawyer, I today confer on you, all of you that are in this class, that going forward, you are all lawyers, barristers, solicitors, senior advocate of Nigeria, Anthony. Just choose the one that suits you.
Thank you, my learned colleague.
Yes, thank you. You are welcome, colleagues. So you are all learned colleagues. We're all together. We're all one. The same at the bar. No one is above another person. So, because we operate at that level, and then of course also because we are lawyers, it then means that we have to create a space, within us to, situate the rules of law. You know, yes, I can see senior advocate here. Yes, that's what I want. And there is senior advocate going forward, right? Just I have to caution that every law, like lawyers in Nigeria, you can't practice in Ghana unless you are also Kotuba in Ghana. And so even your law too, you know your limit of your practice. There are some areas that you should not practice. So know the limit of your practice. Ehen. Don't wear wig and gown to the courtroom yet. You can practice it in the classroom. And then that solves if now. Going forward, I'll tell you further if I need to expand your jurisdiction. So um we are looking at contracts, you know. Um, you know. So the question is what is contract? That's the first question to look at. What is contract? Yeah, someone should read that paragraph just to know that you are all together. Can someone read that paragraph?
Okay, sir.
A contract,
Okay.
Yes, go ahead.
A
a
contract
contract,
is an agreement made between two or more persons, which the law would enforce. The elements of a
No,
contract are
that's
ever
fine.
okay.
In courtroom, you have to when you stand up to talk, you have to enter appearance. Enter appearance is when you tell my lord, I'm barrister this that so the court will give you audience. you know. So how I wish that you go back and introduce yourself properly, barrister. We're dealing with barrister who, and then we hear your matter, right?
Okay, good evening, everyone. Senior Advocate Rosemary Agassi.
Okay, Rosemary's SN. That's interesting. Okay, let's hear you, senior advocate, learned colleague. Let's
Thank
hear
you,
you.
my lord. A
Mhm.
contract is an agreement made between two or more persons, which the law would enforce. The
Thank you so much.
elements of a
No,
contract
that's fine.
are all
That's
right. Thank you.
that's fine. Yes, that's fine. So you see that that's single two-line stuff that is there. It's very heavy, and we're going to digest it before we move on. Now, I said that a contract. If you look at this statement, there, a contract is agreement. So I let's say on that here that for there to be a contract, it must be agreement. But not all agreements are contracts. Now, but then for you to understand an agreement is when two minds have come together, or what is called in Latin consensus ad idem. Two minds have consented, you know, together. So this happened in many ways, even in terms of employment. If someone offer employment upon you, the law is that you cannot force a willing employee on an unwilling employer. So there are many people that are looking for jobs, but they cannot just on their own force themselves to work, I mean, with employers. There must be agreement. Contractors. There are many people that are professionals, with different skills, but you cannot force their professional skills on people unless those people require their services. Suppliers, estate managers, consultants, service providers, logistics person, you have a lot to offer, but you cannot just force yourself. You can't just, you know, boast yourself that look, oh, I'm the one. This is what I have. I must do this. No, there must be agreement now. But because we say that, that agreement, that is a contract must be one between two or more persons. It means that before you say that it's consent, certainly it means that two persons are involved because two persons are involved. That's why I say two. And these two persons, we call them at the time of the offer, we can call them the offeror or the promisor, or you can call them the offeree or the promisee. So there must be two persons, coming together. For instance, between you and University of Lagos, the contract between you and University of Lagos is LLB, sorry, is MBA certificate. That's why you are here, nothing more than that. You are looking for MBA. So that is the requirement of getting that MBA certificate that say you must do uh, business law. And but it's great today you are called to bar. You become senior advocates, barrister, Ade, you know, and barrister who, the one that spoke also, senior advocate of Nigeria also is there, you know. So you are already progressing, you're already making a lot of benefit from it. So now we're saying that look, so it must be two or more, that agreement must be two or more persons. And we use the word person. A person We use that word person deliberately because in law, there when you say person, it's not just a human being. It also includes artificial being. Artificial beings like registered companies, or company created by law, like University of Lagos. University of Lagos was created by University of Lagos Act, and it's a person, just as you and I. So University of Lagos can sue and be sued. You can acquire property. You can hire. You can you know it's a person. So just as we have Ezephili, Priska, Joy, you have Stephanie, you have David, you have Jimo, Abdul, they are all persons. So University of Lagos is also a person. Just as how UBA, you have Zenith Bank, you have Access Bank, they are all person. You have Dangote Group, of course, even the governor. When you called, the stuff was showing what do you call it? CFX, Nigeria. These are all persons, right? Kalu, person. University of Lagos, person. So when you say person, two or more person, it's not only about human beings, right? But it's also about.
Evening. Evening, everybody.
Class governor, I hope you are doing your work.
Yes, sir. I just muted that.
Juliet, be careful. Ndubusi, be careful. You are disturbing the class. Except you are against us. I remember that the class is being recorded. Even YouTube is also live streaming live on YouTube. So Juliet Ndubusi. So back to business. So the point I'm making is that when you say two or more persons, mean that a company can enter into a company with a artificial being can enter into a contract with a human being. You know, so it's like NWC now, entering into a contract with UBA or the class governor now entering into a contract with Cifex Nigeria Limited. You know, and so you can. That's why we say persons. Now it didn't stop there. It said that which the law will enforce. It then means that if there's an agreement, it's that agreement that the law cannot enforce. It cannot be a contract, even though it may be agreement. And so that's why it is said that you know a contract, for there to be a contract, there must be agreement, but not all agreement are what are contracts. Now, note that there are different, different classes of contracts. They are what they call bilateral contracts. Bilateral means that two persons will negotiate contracts, they bargain, and then they negotiate, and then they enter into that contract. Between the class governor and the University of Lagos, contract for LLB, I mean MBA certificates. For instance, it could also be contract of employment with whoever you are working and things like that. That's bilateral. They would offer you the offer letter on appointment terms on. So you look at this one and you like it. That's why you accepted, and then you resume the work as required. Or it could be unilateral, where only one person make offer. I mean, make this unilateral contract is only when one person. It's one person in the sense that in reward cases, for instance, contract or reward. You lost an item, and you say that if any person can find the item and refund to you, you will reward that person. It's only you that are making that. You didn't ask someone to, didn't negotiate with someone to go and look for the lost item for you. You're just saying that any person choose not to comply with what you posted, nothing, no agreement can take place. Unilateral contracts. So in road cases, they are all classified as. You also have what they call executed and executory contracts. There are some contracts that you know, when you enter into, you carry out immediately, executed. You know, contract for purchase. You purchase items in the supermarket. You go to shopping, you pick items on the shelf. You go to the counter, you pay, and you pay the money and go out with your item that you bought. Executed. So the contract is for sale of those items. You came in there and you enter into the contract and you It's executed. Everybody performed his own obligation. You paid the money, the other person also gave you the goods, and you left. Executed. Now, but there are some contract that you enter into, but the performance is postponed. Like construction, for instance. If you enter into a contract for construction of estate or property or building, there's no way that you enter into contract that day and it will conclude it that day. It takes time before the whole obligations are carried out, because contract, what it does is it creates rights and obligations which the parties will enforce. So if your duty is to pay money, it is the right of the other party to receive the money. you know so it creates those rights and duties which the law will enforce. So it could be executed. Contract can also be oral. It can also be in writing. It can also be by conduct. So in writing, you know that what is writing. Of course, orally, when it's made by words or mouth, by conduct, when you not write anything down, not say anything, but the way you acted. And a common example of, when you enter a restaurant for to purchase food item, you didn't talk, but they gave you the food, you took, you ate, and everything, you didn't say anything. By implication, you are bound to pay, even though you didn't say anything. Or maybe you are into a bakery, you are doing bakery bread and all of those stuff, and they supply flour to you. You didn't say anything, but you use the flour and doing bread. By conduct, even though you didn't listen, So of course, even though we have what is called electronic contract also. Many of them, as we're going to see, you're passing by, you saw a blinking light. You go there, you start your card, enter the pin, and keep asking you question on that ATM machine until the point that money comes out. There are many of those processes that take place there. What happened? You send your proposals email, you send correspondence email, you even have your meetings online and things like that. So all of those things, in the context of law, all electronic contracts are deemed to be, contract made in writing, by virtue of section 28 86 of Evidence Act, 268 of Evidence Act 2011. Right. So, this is things that you need to know about contract. Now, going back to the question, which is the point that I made earlier, that for there to be a contract, there must be agreement, but not all agreement are contracts. So it then means that this should be something special in agreement to be called a contract, such that if that thing is not there, it will be an agreement and not contract. So what is that thing that is so special in agreement that is called a contract? Those things is what they call elements of a valid contract. Elements of a valid contract. And that's what you could see up there. How many of them are you seeing there? Can you just read them out? Offer. Let's have a speaker. Who should be our speaker? Someone that has good voice, not no, because they is not someone. Yes, class governor. Who will be the speaker of the class?
Speaker of the
Hello,
class,
sir.
sir.
I can do that.
Okay. All right.
So
Okay, go
so
ahead.
so note yourself. Today you are appointed in the office of the governor to be the speaker. You working in the office of his excellency. So I identify you as a barrister who?
Mary Jane.
Mary J.
Yes, sir.
Okay. Mary Jane, okay. Mary Jane, you are the speaker. Congratulations on your
Thank you, sir.
appointment. Your appointment. Okay, go on. What are those elements?
Offer, acceptance, consideration, and intention to create legal relations.
Good. So this one that's omitted there, there's one, add it up. It's called valid capacity. Valid capacity.
Valid trust.
Yeah. So you have five elements of a valid contract. Offer, acceptance, consideration, intention to create legal relations, and valid capacity. The fifth one, you know, if that one is added, so people that will not attend the class will know when they lie on things outside will know, because some of those things that we say in class are not in the slide that you may, some of you are keeping there. Very important. So it's deliberate. So yeah, so already the when you were called to bar later some minutes ago when you were called to bar, no, there was no objection, no objection. So I assume that you are now you are all lawyers. So there are some presumptions. So I assume that you know offer, you know acceptance, you know consideration, you know intention to create legal relations, and you know valid capacity. Is there any objection to this presumption?
No objection, Your Lordship.
So I presume that you know. So let me skip to another topic.
Objection, my lord.
Eh? Donald, you say what? I mean Donald, what is the name? David, okay. You say what?
So would like you to just throw more light on what this concept means.
As learned colleagues,
Yes, sir.
we will have senior advocates. Well, are you not a senior advocate?
Oh, a baby. I'm a baby lawyer.
This guy is very funny. Like, nothing like baby lawyer.
You advocate.
Florence, you are also you are you a senior advocate?
I'm intermediate advocate, sir.
Which one be intermediate again? Now, wow, I'm learning so much here. Uh-uh. There's a baby lawyer, there's intermediate advocate, there's a okay, Abdul, where are you? Which one do you belong?
I'm a son, sir.
You are a senior advocate of Nigeria. I like that. Oh, someone is saying associate lawyer. I don't understand this one though. Oh, wow. Okay. That means there's crashes on ground. The categories of lawyers I'm seeing here, there's crashes. So there's crashes. So let me see how well I can do. Okay. But we're reminding ourselves what is an offer, what is acceptance, what is consideration, and what is intention to create legal relations, and then the valid capacity. Right? So the first one, an offer. Yes, our speaker, read the first paragraph.
Offer. A proposition made by one party, offeror, to another, offeree, indicating his willingness to be contractually bound on certain terms provided that those terms are accepted by that other party. An offer may be made expressly
Yeah, I
or
know.
implied. An offer may be made expressly or implied from the conduct of a party. It may also be made to a particular person or to the public at large. An offer was made to the public at large in Cali versus Carbolic Smoke Ball Co.
No, that's the first paragraph. That's the first paragraph. There are senior lawyers here, so if you take it too fast, if we just carry with speed like this, some things may happen. So let's take it because of old lawyers. There are some senior advocates here. There are some intermediate lawyers. There are associate lawyers. There are baby lawyers. All classes of lawyers here. Now we are saying that first of all, now for every contract, for every agreement, for every consent. In fact, think about any agreement in your life, any agreement that you ever entered into. Those that are married, that's contract of marriage. Those that are working, that's contract of employment. Those that are employers themselves, they have contract. Those that are in logistics, they are all also entering into contracts, clearing and forwarding every day. Those that are bankers, your bank's customer, that's a contract also between your bank and the customer of the bank. It's also contractual relationship. you know. So think about anything. If you are into construction, there's also a contract of employment on daily basis. Transport, you're also into contract every day on daily basis. If you buy a car, that's the contract for the purchase of the car. If you have insurance cover on your car, that is contract of insurance. you know. So there are many things on daily, even between man and you and God, there's also a contract. And for Christians, you can find the terms of contract in the Ten Commandments. Just obey the terms of the contract, Ten Commandments, and you are in heaven. If you disobey the commandment, you go to her. So it's known. Everything is contract. Even in your country, for us Nigerian, the for choosing our leaders, there's a contract between we and our leaders, whereby those leaders will take an oath that they will rule this country for the benefit of all, not for a select few. And I hope you know that that's what our leaders are doing. I don't want to start that topic because lawyers will give me different versions of this answer. So I will stop there. I won't go to our leaders, but just know that between us and our leaders is also contract. So we go into contract on daily basis. Now, for every contract, start with an offer. So when politicians come to you, if you vote me, I will do this, I'll do this. They're all offers. They're making offers. So, and you accept those offers by casting the majority vote so that that person will become your leader. At that point, the person is to lead in accordance with the terms of the rules of the nation, which is the Constitution of the Federal Republic of Nigeria. Now, so in the context of business transactions, and when I say business transactions, are those activities that will generate profit and it will be shared. And when I say profit, it's not reward in heaven. Profit is the reward on earth. Monetary, money. Those are accountants. Whatever the assets, it must be converted into monetary form. Ego. That's the business I'm talking about. So when you come into a business setting, we're saying in the context of it, there's someone will always make an offer. And but we're saying that it doesn't start that way. You will see that if you had this experience whereby you know you saw an advert for a job, you apply, they call you for interview, you attend an interview, they do a test on you, and then later come from the company saying you are admitted, you are offered to, and then you accept, and you so you see that so many things would have happened, so many preliminary, so many bargain negotiation. Even at the time of your interview, they will ask you how much do you think we should pay you that you okay. So many bargain were at that level. Or if you're a consultant, or if you're a contractor, imagine so many, and you are bidding for a project with federal government or any of these agencies. Imagine so many contracts you would have, meetings. You would have entered so many meetings. Imagine you want to borrow money from the bank. You enter so many meetings. You sign so many documents. So if you want to buy goods in a shop, the shop would have been open. Goods will be displayed. You go inside, you pick one, you go to the counter, they will say this is, and then you pay and you go out. There's a lot of things that go on there. University of Lagos, they would advertise for MBA program. You saw it, you apply online, they shortlisted you, they call you for examination. You did the exam, you passed, you call you so many things were done before you are not in class today. So you see that it's difficult to situate at what point in offer made in a business. At what point is that offer made? But we're saying that that offer is the beginning of every contract. Every contract starts with offer and follow with acceptance. Every contract.
Wow.
So we're saying that that contract, how do you now identify an offer in this chain of activities? How do you identify offer in this chain of activities? Now, as lawyers are social engineers. Social engineers in the sense that if if you take your car to mechanic, go to the workshop, they have several tools that they will pick those tools and are checking the car on what exactly they need to do in respect of in that regard. So they're checking and checking and checking and checking and checking all those things, right? Now, what we're saying here is that an offer, you know, when they check this in, as in, other engineer, they will fix it until one tool will help. They will remove those things and they will repair it and they fix those things back. Now, as a lawyer, you are a social engineer. There's a problem in the society, so they come to you to fix it as a lawyer. What do you do? Is the rules. The tools you use are rules of law. Rules of law that you use in fixing it. So if they come to you and are saying, "Oh, we're not sure we have offer and acceptance in this contract," so you, with the knowledge of offer, you should be able to detect that, oh, of all the discussion, this was the point that offer was made. So what this class will help you is to identify. It will equip you to identify when offer is made, so that you know that parties had entered into a contract or not. Because if there's no offer, there's no contract. Or because all contract must start with offer. So how do you identify an offer? That said that offer is a proposition, it is a statement, it is an expression. And that expression or proposition or expression is made by one person. There's always one person that will make that person. Irrespective whether it's a company, whether it's a human being, whether it's a woman, whether it's a man, all we're saying is that one person would have made that expression statement, would have made a statement. That statement, as I say, a contract could be in writing, it could be oral, it could be by conduct. So that statement can be in writing. That statement can be orally. That statement can manifest by, because as I say, agreement is from consent, it's from the mind, manifestation of the mind. Because if you have consent and it didn't manifest, there's no way that one will know that you have, you know, that's why silence itself cannot difficult to know whether it's contract because of silent general speaking doesn't amount to acceptance. But we'll come to that. So that person that makes that offer, it makes the expression or proposition or statement is known as the offeror. And it makes another person known as the offeree. Now, indicating his willingness, who is indicating? The offeror. That's the first person. Oh, is expressing indication that look, oh, willingness to be bound on terms, provided that those terms are accepted by the other party. And the other party is the offeree. So closer home, University of Lagos, for example, assuming that as we're going to see, I'll ask you to tell me the answer. But assuming that University of Lagos gave you offer of admission. So you see that university will telling you is willing to create a binding contractual relationship with you. That's why the university was expressing needs, and it's saying that the university was saying in that admission letter that it will be bound by the terms contained in that admission letter, provided that you accept those terms. So that's why if you now begin to twist, instead of accepting the terms as they are, you change it will be a problem. So we're saying that an offer is a proposition, it's an expression, it's a statement. It's manifesting from that consent, from the inner consent, because if you have something in the mind, but you didn't manifest it, there's no way that anybody would know. So you manifest that intention. And the person that manifests is known as the offerer. To whom that is made is known as the offeree. And of course, the offerer is the willingness to bound by terms provided in it. That's why we said an offer may be expressed, may be implied. Express in the sense that orally speaking or is in writing, you can detect it with your senses. By conduct is by implied. You know, and because so if they give you food, you didn't talk, but you eat. It's implied that you like the food and you pay. You can't say that you didn't ask for food. You're coming to school, you stood by the bus stop. Okada man came and carried you, brought you to the university gate. You are saying that you didn't ask Okada man to carry you. Eh, okay, you told them on tire. Okay, so the offer can also be made to a particular person. So an offer can be made to the class governor, it can be made to only stream. Which stream are you?
Stream of
Sorry?
Stream one, sir. Stream one.
Okay, year what?
Yeah, one, sir. Stream
Year
one.
one.
Yeah.
Okay, stream one, year one. So it can be made to just stream one, year one, or it can be made to stream two, or it can be made to all the students of Faculty of Management Sciences, or it can be made to all the students of University of Lagos, or it can be made to all the federal universities, or it can be made to all universities in Nigeria. It can be made to all Nigerians. It can be all to the whole public at large. And this analysis of what we're saying here was expounded, detailed analysis was carried out in the case of Kali versus Carbolic Smoke Bowl Company. Now, it's a case that every student of law of contract must know. It's a common law case in all common law jurisdictions. All students of law of contracts must know this. So, I give you 2 minutes. Use your phone, use your gadget, what you're learning with. Google this case online, and I will ask you in 1 minute time what are your findings, what this case is all about, what happened in that case, and what was the decision of the court. Because the case we're going to meet the case in several places. It has so many principles that we're going to apply in several other places. So I give you 2 minutes. Google it. Let's discuss it. 2 minutes. Is 1 minute gone? Yes. You can to raise your hand. Yes, yes, yes. Those are finished. Can I just raise your hands? Yes. Yes. Oluwasegun Abdul, Senior Advocate of Nigeria. Address the court. Oluwasegun Abdul, Senior Advocate of Nigeria. Address the court.
Okay, your lordship, sir.
Yes.
Okay, so sorry, sir.
Okay.
The Kari versus Carbonic smoke ball. It was actually a case that happened in UK in 1892. So the fact of the case is that there was a flu in UK and the flu was very deadly and people were dying. Then Carbonic smoke ball company came out and said that they have a cure in form of an inhaler. So Mrs. Kai, which her husband is also a lawyer at that time, bought this particular inhaler. So when they made an advertisement that they, that if anybody buy the inhaler, that they'll be cured of of this particular flu. That if they are not cured, that they should refund, that they will refund them £100, £100 at that time. That they also went ahead by saying that they have also placed a £1,000 uh, somewhere in probably in a bank that the, it will form a kind of what is it called, to repay anybody that pay back that return the inhaler. Hello, sir.
I'm with you.
Okay, so to convince them that they will refund, to convince them that the inhaler will actually cure the people, that they will refund the £100, and also they also went further by saying that they have kept the £1,000 in a bank somewhere, for this particular purpose.
Yeah. So what was the decision of the court? Hello?
Okay, so in the first hearing, so the decision of the court carbonic in the first hearing, carbonic snowball actually won. They actually won that particular case, right? So, but in the appeal, when Kali actually appealed in the court in second hearing, so the decision of court is that there were elements of contract. There were some elements of contract in that particular advertisement. Normally, that advertisement was actually is supposed to be an invitation to treat, but there were some elements of contract in that particular advertisement. There were offers, there were consideration. Then there were also intention to create a legal relationship, right, in that particular case. So in the second and the third hearing, Mrs. Khalil actually won the case.
Okay. Let's go to let's go to yes, the section, yes, you can take it down. Yes. Mary Jane, let's hear you. And then Osas. And then the class governor, yes. Mary Jane, let's hear you.
Okay. So just to add to what Shegun said,
Mary Jane,
the,
senior advocate of Nigeria, I guess.
can you hear me, sir?
Oh, you are also senior advocate of Nigeria.
Yes, sir.
Oh, great, great, great. You are welcome.
Okay. I just want to add to what Shegun said. The company Carbonic Smoke Bomb placed an advertisement that anyone that use their products, um, and that use their products following the conditions stated in the terms, if they use the product appropriately and they still contract the influenza that was going wild, then that such a person would be entitled to £100 reward. Then Mrs. Carly, after purchasing the smoke balls, which is the treatment that they made for the influenza, still contracted the influenza after following the steps they stipulated. And then the company, instead of giving her the £100 reward, claimed that there was nothing to give to her because the advert was just for her to use the product, and the £100 that was stated as reward was not to be given to her. But after the back and forth, when Mrs. Kali appealed the case, the court held that Mrs. Kali had a point and she needs to be given the £100. Reason for that is there is consideration. The consideration is in the form of the use of the ball, even though the wordings of the advert were not really clear, but the fact that it implied the terms such contract is viable. Then they also said it was in this case that it was stated that a person or an entity can really have a contract with the public, and such contract does not really have to be reasonably clear, but it could imply. And this case also, the court also held that the fact that Mrs. Kali used the used the ball, yeah, that was made for the influenza showed that she provided acceptance. So there was acceptance, there was consideration,
Okay.
there was intention to create legal relations and all that. So the
Okay.
advert itself was sufficient.
Okay. Thank you so much. So at least you know why I deal with the class owner have taken down the hand, so I know that you don't want to say anything again. So now the point one is making here is that if you look at I expect all of you to be reading it. There are many cases there. You know, the fundamental issue was that one of the arguments that Catholic Smoothball Company was defense what they were bringing forward was that look, we say that any person who use our product, any person, so they are holding their hands on that any person, that any person is vague, is vague. It doesn't mention Kali, so Kali cannot claim that the offer was made to her, right? So, but the court said no, the offer can be made to any person, including the public at large. So, any member of the public that respond to that, it becomes binding on Cabal Small Company, as the case may be. Now, to further show, guide you or provide the skills for identifying an offer in a business transaction, there is what they call element. Just like we have element of contract, we also have element of an offer, right? We have element of, so the first element there is that, as we see in the bullet number one, there is that it must be definite, it must be certain, it must be unequivocal. Otherwise, the proposition or the expression or the statement will be regarded as invitation to treat. So that's one that you should note, that it must be definite, it must be certain, it must be unequivocal. Now, I mean, give you one. Let's look at one example, for instance. We can use let's use the contract for contract for for rent of an office space. Now, assuming that Mary Jane sent a message to Abdul, senior advocate of Nigeria, and the statement reads that Abdul should, and the statement is that she want to rent office space from Abdul. Assuming that Abdul has so many office space that is, has a plaza that is, and just say, you know what, I offer to rent an office space from your plaza. That is the statement. They just make that statement and stop there. Now, what's wrong with that statement? Does it constitute an offer? Does that statement constitute an offer? Are we here? Do you see Apple in this class?
Sir,
Very
can
well,
you
sir.
come?
Can you
Yes, sir.
retake
Yes, sir.
the question, sir?
Can you come? Can you? Okay.
Kindly take that again, sir.
I'm saying that, assuming a scenario whereby Abdul just finished building plaza with offices, office space, shops, and all of those ones. Now, Mary Jane sent a message to Abdul that she intend to rent office space from Abdul. That is statement. So I'm saying, is that statement an offer for the rent of an office space or not?
Sir, uh, Barrister Ishala
Of
Ayedele Samson, sir. Your Honor,
sure,
sir.
that's a senior
Just to
counsel.
add,
Yes.
just to add to the
Anybody that want to comment should raise up his hand so that I can monitor his
okay.
online.
Oh,
No,
oh,
wait, should I
I'm
go
sorry
on? Go
about.
on. No, go on, go on.
Thank you, sir. Sir, for a contract to actually take place, there must be an offer, and from is is a is a is a one or two things. It's not necessary that Abdul that actually constructed the building has to be the one to. Yes, ideally, he should be the one to put on an advert for rental
No,
of his.
we don't want to go. Just give me an answer within the facts I pointed out.
There's
Don't.
an offer, sir. There's
There's an
an
offer.
offer. It's not for Abdul to accept. There's an offer.
Okay, let's hear from His Excellency,
Your Lordship.
Senior Advocate SARS.
Yes, sir. So, based on what my lenient legal luminary just mentioned, I opine objectively that there's no contract in place, sir. Thank you, Your Lordship.
We're not saying contract, we're saying offer. Was there any offer?
Sir, offer. No offer in place, sir.
Why? Why?
Because,
Why?
sir, okay, sir. So, because based off what you just mentioned, the elements of contract supposed to have some certain which is number one offer. So
I'm not discussing element of contract. We're still discussing offer.
yes, so I think yes, sir,
Why?
because it's just blank, it's just vague. It's just vague. Like what Trevor mentioned, it's possible that Abdul didn't actually own the property, probably built it. So it could just be
No, it's not in doubt.
that
I do owns it. So don't bring things outside the question. I do own the shop. Okay. So let's
does
hear
not
from, yes. Okay, I heard you. The government is saying there's no offer. There's no valid offer. Let's hear from who was second. Mary Jane. Mary Jane, you are the one that asked, made a statement. Now you still want to give the answer. Okay, go ahead. Let's hear from Mary Jane. You don't post wahala now. You see, you want
Okay.
to. Mhm.
So I feel there's no offer, and the reason
No, no,
for
no.
that is because
So
it's
like this
not
side.
definite.
It's not what.
It's not definite. So it is what it's just an invitation to treat. It is not an offer yet because there's no time. I think there should be time factor to it and some other elements as well.
Okay. Let's hear from. Okay, let's hear from Patrick Oladijo.
No,
Kai,
from
Kai,
my
please
own,
call us as background. Wow.
hello, hello, sir.
Yes.
From my own view, I think there is offer because it's clear and definite. So it's just that the contract has not been made. There is offer.
There's offer. David.
Okay, so, for me, I think there's no offer yet. Yes, there's a structure in place, and there was an intention by the other party, but to me, I think the best you could qualify it is an invitation to treat.
Okay.
Thank you.
Okay. So you see, I made a statement. That's why I asked this question. It's very deliberate because look at what I said here. Element number one, it must be definite, it must be certain, it must be unequivocal, it must be clear. Now, assuming that someone has many shops and you want to say, I want to list one, won't you, when that person asks question, won't that person ask for a question? Won't you ask question as to which one? At least you can ask which one. Is it not so? Won't you ask that kind of question, class?
Yes, sir.
Won't you,
Yes, sir. Yes, sir.
oh yes, you
Which of the
ask.
shops on the
Exactly.
Yes,
You ask which of the shop.
in the plaza?
Exactly. There's a plaza, and I said there are shops that are, in fact, if because the plaza, you will even ask, is it upstairs or downstairs? Is it which size? Because some of them will be bigger than the other ones. Is it corner piece? Which so there are many questions that are still unanswered. What is the price? At what rate do you want to lease the plaza? What price? Is it yearly or is it for 5? What for what duration do you want? So you see that there are many unanswered questions. That means that that statement is not definite. So it means that Abdul will still need to ask further questions, and then the response from Mary Jane, and then that response will also require questions again. Ask for so you see that they'll still ask questions to make inquiry to find out more, to find out more, to find out more. Because just means that that's first statement made by Mary Jane is not definite, so it cannot be an offer. That's element of it must be definite. Now, the overall must be willing to become, to be committed to the offer as soon as later accept the proposition. Otherwise, there's no offer again. So what that means that Mary Jane must be willing from that statement, because already we said that the statement that he made, assuming that that statement was valid because he contained all that is required of it, the price, the size, the duration, the nature of it, and everything, upstairs or downstairs, the case may be. Assuming that there must be that willingness to be committed. And of course, the offer must be made by a capable person. The person must have capacity. For human beings, the age of contracts 18 years above. Of course, for companies, contract is in the object clause in the memorandum of a company, and the offer must be communicated. So there must be communication. So when you make offer, you must communicate to the offeree, either in writing, orally, or by conduct. So if this element of offer are absent, then at that stage we are saying that it's still invitation to treat. And the meaning of invitation to treat is that parties are still inviting the other. Let's come and go into a contract. Let's go into agreement. That itself is not agreement per se. It just offers. They're just offers. They're not agreement. In that regards. So why an offer? A contract starts with an offer. Invitation to treat It's just a preliminary stage, just as when you want to play football and then you are doing warm up before the game. But you know that once the referee blow the whistle, the game will start. At that moment, all play, against your goalkeeper, score your goalkeeper, touch the ball will stop. So, as lawyers, you are trained to detect in this chain of activities where the offer lies. So, be looking for those features. This statement that they're arguing whether it's an offer or not, was it definite? Is it ambiguous? Is it a statement that you can ask further questions? If that's the case, then that means that cannot be an offer. Because an offer, you are expressing something within you that you want that person to consent. So that should be in a manner that the person understood clearly what you meant, and he also now give the consent. But if it's a statement that will lead to other questions, other inquiries, that means that statement cannot be an offer because it's not definite. You must communicate. You must be willing to be bound by yourself. You must have the capacity. So assuming that Mary Jane is 17 years, that means he cannot work because he doesn't have the capacity to make that statement in the first instance. So it cannot be offer. So you see that every age have a factor. Or assuming that it is that statement came from UBA and is for a construction of and UBA is to construct a bridge or construct high rise to construct a road. UBA doesn't have any powers in their memorandum or in their object clause to construct bridge. They don't. They don't have capacity. So what I'm saying is that these are things that you look at to weigh or to assess a statement to know whether that statement is an offer or not. Because in a business transaction, there are so many discussions that will take place, and they all link up. But the ability of a lawyer is the lawyer will not detect at one of the point of that chain an offer was made and by who. The person that makes that offer becomes the offeror. The person that statement was made to becomes the offeree. Right? Any question? No question. So it then means that is how we now detect, how can you now distinguish between an offer and invitation to treat? How can you distinguish? So there are many ways. And because of difficulties in detecting there are many ways that are used in demonstrating this. Many ways that you can use in demonstrating offer and invitation to treat. One example is by way of advertisement. No matter that in Cali and Kabul Smuggle Company, the company advertised their products. It was a pharmaceutical company. They advertised that pharmaceutical product that if you take it, the influenza will stop. And to assure the customers, they said that they deposited, 1 million pound in the is it 1,000 pounds in their bankers, so that if you take the drug it doesn't go, they'll compensate you with 100 pounds. So it was not to advertisement. So you see that in business, people advertise their product. People advertise. If you go on radio, you open your radio in the morning, the advertisements are going on. You go on television, advertisements are going on. In fact, some televisions is all they do is just advert, advert, advert. You buy your newspapers, advertisement. In fact, there are some dedicated magazines only for advertisements. People that have supermarket, they put advertisement. Banks will put their signboards. UBA is here, oh, Zenith Bank is here, Access Bank we're here, oh. They open their door, will be blinking. Filling station, you see their own display. That there's Fort Oil here, there's MRS here. Now, so it's based on that advertisement. You don't come and buy a product, you go away. It's based on that advertisement. You don't enter and buy your shop in the market and you go away. Now, the question is advertisement an offer or invitation to treat? If it is not, then at what point in that analysis or chain of activities an offer is made? If you buy a car, a car stand will display, car were there. You pass by, you saw a car, you bargain and you price and you bought the car. Is the advertisement of those car an offer? Or if it's not offer, at what point the offer was made and by who? Is it the customer or the car stand or the owner of the cars? At what point? Any comments? Any comments? Hello, do you start people in this class?
Yes, sir. We are here, sir. No comment, sir.
So where is no? It's not. You can't say. So the governor you are leading people to say no comment. So okay, you pay me to talk in a day. I'm not a pastor. So you pay me to. So you will sit down and be taking your dinner. Let the man making noise, right? Lie, oh. People must talk. Oh, cannot cheat me. I don't agree. Oh.
Yes, sir. I think for the filling station is at the point when you driving to say that you want a certain liter of free for your car. I think that's the point where an offer is made.
What
But
makes
at
you
that,
so? What makes you so?
sir,
What makes you feel so? What makes you? What are the rules of what are the rules of an offer that guide you in arriving at that decision, at that thinking?
yes, because it's definite now. You want is a let me say a number of liters for your car. So that
Yeah.
is a definite figure, which is I want 10 liter for my car. Okay,
Yes.
so and then uh, you have made the offer for to say that sorry, the station has said that it's 800 and something naira per liter. So then the amount is already there. So you have consented to pay that amount per liter for the 10 liters of fuel that you want. So I think at that point, that's where an offer is made. But mere passing and you see their signpost, there is no offer. That's just an invitation to trade because you can decide to enter or not to enter.
Okay. Now, but Dada, Rotimi, you are saying something different. So you are saying something different from Adeyemi. So let's hear you, Dada Rotimi. What makes you feel that offer will happen at advertisement level?
Okay, good evening, sir.
Yeah, Dada of
So,
Council. You are senior advocate as well, I guess.
yes, sir.
Dada
So,
senior
my
advocate of
thought
Nigeria.
is at the point of advertisement, I think an offer has been thrown open for the public. So, the acceptance is now left for the customer to walk in and say,
Okay,
okay,
so now,
I'm interested in this.
yeah, so remember that whatever you are saying, you should be guided by rules of law. Because rules of law are like that's an instrument that you use in solving that problem. So which rule of law or which rule of offer is helping you to identify to say that a advertisement of shops, goods display shop or supermarket or filling station, those adverts are offers. Which of the rule that are you using as a guide? That of cancer.
Okay, sir, if I'm to pick any of the rules,
Element. Look at the elements.
is
Look at those elements of. Look at the elements of an offer. Which one suits into what you are saying? Hmm? Rotimi of Cancer. Are you with us?
still
Or you want
with
to
you, sir.
you want to consult the library? You want to visit the library? Oh, are you seeking adjournment? You don't want to. If a lawyer cannot provide the answer, seek for adjournment. Their next
I'm
adjournment date.
seeking for adjournment, sir, for now.
you know, when a lawyer hook for court, he will just seek for adjournment, my lord. I want to go and study this matter very well. I'll come back next time. You want you want a date. Okay. It, don't keep us here. Oh. You have to be very careful. There are also some senior advocates here. So you don't just make a statement. Oh, you have to be guided by law. you know. So you don't just make a statement and then when you ask which law is guiding you, then you seek for adjournment. It means that we'll just I'll select you like this. We're watching you, put you under alert. That this lawyer don't come again. Oh. You give us such a law, and then which law? You say no adjournment. I'm coming back later. So we're watching you now. Don't tell me, don't tell me we're watching you. So if you don't have a law that is guiding you, then don't come to our court. We won't give you adjournment
All,
again.
all, All right, sir.
We won't grant you adjournment again, no, because you must give us the law, eh? Because you are the law. By the way, so that I don't waste time. So generally speaking, you see that advertisement, as we've seen in Cali and Cable Smuggle Company, they are not offers because they're not definite. Imagine that look at how Ademi explained that so neatly, so calm. When you see senior advocate speaking, he's so calm. Ademi was speaking so calm, citing authorities, offer Cali and Cable Smuggle Company and everything. You know, Even the to me wanted to cause Kasara, but it's like a job and no wala. So issue is that it become definite because imagine now you want to buy fuel. If advertisement so how many liters are you selling? So you see that some people will go there will say, how many? They will look at the price alone. They will run away. They will carry the car and run away. Like, I won't buy at this price. They're assuming that the filling station is making offer. Once you stand there to buy, you must buy because it's acceptance already. The contract has come into existence. Shop also, when you shop at display, advertisement or all these shops, or banks. If banks had opened the advertising for their office, when you enter the bank, what do you want to do in the banking hall? If you want to withdraw, everyone want to withdraw, how much do you want to withdraw? So you see that some people go to bank to withdraw, some to deposit, some to make inquiry, some to, pick the form, open account, so that many things. So they are not advertisement are not, generally speaking, they are not you know. So, like display of goods, when the customer comes in and pick those goods, that become definite that this is what the goods he wants to buy, and of course, because the shop owner can reject or accept as the case may be, right? So, thank you for that, Adeyemi of Cancer, and thank you Dada also of Cancer. The two lawyers taking opposite direction, and then the court have ruled that Adeyemi have won this matter. Judgment is in favor of Adeyemi. So, Dada, you have the right to go on appeal, but that's our judgment. So, we go
Thank you, sir.
to so go and throw one party. You won the case today. Your first case after court bar. You know. So the second one, you see, you can read the case of Pharmaceutical Society of Great Britain. It's the same thing that happened there, and then you can understand all of those things there. Now, uh, also you can see the case of. I mean, that's once another side of the issue of bus stop. All this BRT that you see there, or you have bus stop, you have BRT buses stopping. You see that at that BRT or bus stop, people will stand there. The bus will come, and people are entering inside. So between a bus owner, that is the transportation now, the bus owner and the passenger who is making offer, which one is invitation to treat? Like the first one, advertisement was saying that advertisement are invitation to treat, while the customer that picks the goods makes the offer. Now, in the transport business, also transport contract for transport for instance, passengers at the bus stop, the bus is there, passenger has come to enter. Between the two of them, who is making an offer, and where was invitation to treat, and who makes an offer? Yes, lawyers must the other counsel have done their matter today, so I won't entertain them. We want new lawyers. There are many lawyers in this court.
Your Honor, if I may, sir.
Yes, go ahead.
So it is the BLT buses that are making the offer in this case, sir, for the passengers to come in. So they've displayed the buses at the bus station, and is an offer being there at the time for coming. Thank you.
Yes, David, let's hear you.
Okay, I think I would like to beg to differ. So I think that the
Lawyers
the
don't start
BRC
again.
buses were the one with invitation to treat because they parked their bus at the bus stop, and when the passengers saw it, they made an offer by entering the bus. Those are my
So
comments.
who makes the offer? Is the passenger.
The passenger, I think.
Hmm. Interesting. So, what are they? So you see, in the situation of boss and and a passenger, it's a delicate issue because you will observe, in those days that you didn't have a car in Lagos, you will enter a bus and you say, "Oh, please drop a mistake." The bus driver will drop you. They won't charge you any money. You come back. So assuming that the bus is one making over and you have entered, of course, what would have happened? Contract has come into existence, and you must go on. So, generally speaking, when it comes to issue of offer and acceptance, I mean invitation to treat and the and this thing and invitation to treat and um, you know offers in the cases of transport is a question of facts and circumstance. And so the guiding principle is that in the case that that bus has the route written on it, that bus that will tell you from this bus stop to this bus stop. So already you know that that's the route they are going. In that case, you can say that one, so that when a passenger enters, he knows that this is where he's going. Now, even at that, but if a bus has multiple buses, a bus stop that is stopping on the way, like from Yaba to Ikorodu, you would have stopped severally. You see that even at that point, you see the bus will not be making offer because is it Ketu that is dropping or Ikorodu or where or is it mainland that you're dropping? You're not definite yet. So at that point, it's the passenger that enters and say, okay, enters when they say, "Oh, K2," it becomes definite that, "Oh, this is where it's going." So if that driver is not going up to K2, we say, "No, I'm not going up that." So the offer was rejected. So you see how it play of all of those things. So it's not as straightforward. It's not as straightforward as. So even the sale of shares, purchase of shares, when you want to add this, prospectus for sale or subscription of shares by members of the public, and you subscribe. So between the subscriber and the company, who is making offer, or what is advertisement? I mean, what is the invitation to trade? Businessmen in the sale of shares or purchase of shares, company shares, who makes who what which one amounts to invitation to trade and what one amounts to offers. Yes, do you have lawyers that want to appear for this matter? Okay, so take note of all of those ones and then look at them. Invitation for interview for a job or interview for admission into exam. All those invitation for interview, they are not offers. It comes from the employer when that is given generally. So you will see that in those scenarios that I pointed out, you can always detect those instances where the offer is made and where the offer is not made, as case may be. Now, one other aspect that we need to talk about is termination of an offer. Termination of an offer. When do the life of an offer comes to an end? There are many ways. I'll just give you some. Go and read some yourself. One is by revocation. Revocation. When you revoke an offer. Revocation means withdrawal of an offer. When you make an offer, but before it's accepted, you can withdraw it. So in this case, who withdraws between the offeror and the offeree? Who withdraws an offer? Who withdraws an offer? Who revokes an offer? I'm asking the question, please.
Is the overall?
The offeror, exactly. So it's the offeror that offers made a proposition to the offeree. So it's the offeror that will withdraw can before the offeree will accept, he can withdraw it. And once he withdraws it, the life of that offer has come to an end. So assuming that in Cali and couple of small company, for instance, if before Miss Cali bought the company that took, withdrawn that from the market, that's the life of that offer would have come to an end. It will also terminate by what? Rejection. Rejection. That is the offer. Offer is made and is rejected. So just as I asked for, between the offeror and the offeree, who rejects an offer?
Offeree.
Sorry.
Offeree.
Ovary.
Exactly. So once an offer is made, and so when you enter the store, you pick the item at the counter, the person says, "So sorry, sir, we're not selling this one." You go to a car stand, you identify a car, you want to pay. Say, no, someone has bought it. You saw a house, you want to list it. Oh, this shop, the plaza. Oh, okay. Mary J has gone. Okay, this is one that I want. So, oh, someone has taken that one. They will have others available. Rejection, right? Some it's also by lapse of time. You know, the offer that will say kindly accept within 2 weeks. Your admission letter, for instance, your employment letters will give you time within which to accept. If you don't respond within that time, you know what happened? It comes to an end. The life of that offer comes to an end by lapse of time. Death, you know, death will also terminate the life of, where there are two ways. There are some contracts, there are some offers that may be accepted even after the death of the offeror. There are some contracts that can be performed, but it is a personal contract. Like the one you are doing here, admission, being a student or University of Lagos is a personal contract, which they cannot delegate to, another person. So assuming that anyone here is you are twins, maybe Taiwan and Kende or Edo. So if Kende is doing this program and decide not to go on, they can't pass the certificate. I mean, they can't pass it on to Taiwo or Kende, vice versa. We can't say, me, I don't want, let me give my sister, or let me give him this certificate. No, you can't. It's personal. So there's some contract of employment, for instance, they're all personal contracts. So if you come down to the issue of offer, where they are personal, the death of the offer or the offer terminates the life of that offer, you know. So, ladies and gentlemen, these are some of the things, the ways by which the life of an offer can go. And then, so once the life of an offer has been terminated, it means that nothing, you can't go on again. No offer, no nothing. You can't accept that again. That will be the end of that contract. You have to renegotiate if you want something like that subsequently. Ladies and gentlemen, that is what I want to, I may like you to know. As I say, there are many things about it. These are things I want to highlight for you to know with respect of offer as an element of contracts. Right? And I hope that with this little I've done, if you go practically now, practically, if you go into like you go to maybe electronic contract, for instance, where you go to a bank, let me ask this one, electronic contract. You saw ATM blinking light, the green light, you start the card. They ask you for numbers. Okay, put in, display some name. You keep pressing and pressing and pressing, and then end of the day, 10,000 came out or 20,000 come out as what you have, the bank has what you have withdrawn. Now, in that chain of transaction, from the display of that ATM machine up to the moment, up to the time that you withdraw that the money came from the machine, at what point can we say that an offer has been made? Who makes an offer? Is it the machine, the bank, or the customer? If it's the customer, at what point? If it's the bank, at what point? Yes, who can answer that one for electronic offers?
Okay, so for me, I would say it's the customer that gave the offer, as at the point when you plug in the amount you actually want to withdraw. So at that point, you were definite of what you want from the ATM machine.
Great, great. Okay, so at least this is what we say cool. So we see that if this just if you go someone that some of you that are into this, just go to I mean ATM machine. What we're discussing today, go and be observing it and see what will be going on there. Or you go to a super store, you take things to the counter. Someone give you a POS, you put the POS the card inside. You are struggling, they will say decline, this and that. While you are doing, someone else has bought those items that you want to buy. Was there a breach of contract? So many things are going on. Or you send an email to somebody, the person has not seen that email. Has the offer been communicated? Which rule apply? Is it that until that person receives the email that it becomes a valid offer, or when immediately you send the email, even if that person has not received it, the offer has been communicated? Because remember, one of the rules is that the offer must be what? Communicated. It must be communicated. So when you pay money, it declined, or when you send email, you are not the person has not received it, but you have sent it. So the unfortunate aspect of it is that we don't have any law on electronic contract in Nigeria. So we just harvest some of these rules and try to integrate in it. There was a bill for electronic contract bill, that was brought in 2007. But up to now, they have not passed any law on that. Right. So just is what just I want to bring to your attention. Um, and then we'll go next to. Is there any question?
Yes, sir.
Yeah. Okay.
Sir, I want you to at least give a bit of clarity to the area of termination of contracts, specifically on the aspect of rejection. You gave some example in the case of a customer going into a shop and picking some item, and then maybe the salesperson is now saying the item has already been taken up, so the person can, so that's a rejection. Now my question is, because we said it could be rejection could come in either way from the offeree or the offerer. But
No, 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 no.
okay, so I want to get clarity on that.
Exactly. No, is that's what I was asking now. The what comes from the overall is revocation, revoke. The overall
Okay.
can withdraw. Why rejection is the overall that can reject. Please, so I express myself. This is what I want to you to. I want to do with you, and I promise that if I say these terms, it will bind on me. You can say no, I don't want. You can reject.
Okay.
So by overall saying it can be orally, can by writing, or you can also be by conduct. Like when I give you admission, you just look at the admission letter and you didn't just say anything to them. You went to obtain another admission abroad. So by conduct, you don't want to, they invited you to come and be MC of a ceremony, offered to be an MC at the ceremony reception, and you will pay it. And on that day, you already book a flight going to France for a holiday. By implication, you have rejected that offer, even though you didn't say any communication to it. You understand?
Oh, very well, sir. Sir, there's a second question, sir.
Yeah.
So the
Go ahead.
question is basically on the issue of electronic mail communication.
Yeah.
Because we had some instances some few years back where we had to have some issues with the revenue authority. They said they've sent a letter via electronic mails. Meanwhile, we've not received the mail.
Yeah.
Demanding for liability and all that.
Yes.
And the actual fact, we didn't receive the mail. And they're proving that they actually sent the mail to this particular mail ID on this particular day. So in such scenario, what's the position of the law? Because in actual fact, we have not actually received that mail and the document was not delivered.
Yeah. So the rule is that he who alleges must prove. So if the FRS are alleging, they must prove beyond reason. I mean, on the balance of probability that it
They
was.
actually they showed on their mail tray that they actually made that mail. They sent it, but in the actual fact, the mail they sent it to did not get delivered.
That's what I'm saying now. So it's not once not delivered. And that's one thing about the we say that law is not certain. You know that in some countries, India and some other common law countries, they have specific law that define what to happen in that. For instance, once you send it, the one the selling system is one that is sufficient. That in some they say the ones you send, then it's sufficient. Even if the other person has not received it, as we're going to see issue of like post office, for instance. So it means that because email, once you send an email on your system from what I knew, that's phone handset that you have holding there is being controlled by different companies from different jurisdictions, different software are in a phone or in a computer that are controlled by different companies from different countries. So an email that you send on your system here, it travels so many other countries in the air before it lands to you, even if you are in the same country. Even in Nigeria here, who wants to send an email in Nigeria to someone in Nigeria, that email someone would have controlled it somewhere in a different country before it lands to you back here in Nigeria within a couple of seconds. So some argue that look, because you don't have control how the email will move once it's click sent, you don't have control how the email will move. You should be deemed that that's sufficient. But others say no, it must be received. That's what other law say. But in Nigeria, nothing. We don't have any law. Whether we are in the receiving or we are the one sending, nothing. So maybe you are the one that can help us develop the law in this area. After you are a lawyer now.
Thank you,
You're a
sir.
senior advocate of Nigeria. So it then become the how strong your lawyer was. You'll have the lawyer that you hired, how strong was the argument based on whether but the fundamental issue is that FRS is the one that have the duty to prove. Now, if they are able to prove, then the burden now will shift to you, your company, to also prove that the friend that look, it wasn't delivered. And you can't do that unless you involve the computer engineers. They're the one that will tell you whether this was it delivered or not delivered or not. So you need what they call experts. You would have invited experts as your evidence to prove, as your witnesses in that regard. Not just saying it. None of them, who among them were computer experts in the team that visited you.
Mhm.
Mm. But because their authority, their government agents, so sometimes they use that government this thing to intimidate.
Mhm.
Yeah, that's what they do. But because ask them, any of them on that team that visited you, is there any of them that was computer engineer, software? If they are which type of computer this is it software engineer or which one? You would have asked that question. They are not experts. They're just most of them are accountants, they're auditors, they're just doing their work. They're not experts as to how an email travels in the electronic system. But because you're afraid of them that they will give you query, give you this and that. So, but they're human beings. At least that none that was spoken in this class. If they come again, I know that you have the ghosts, you have what it takes because you are not a lawyer. You can ask them some fundamental questions. And they'll be like,
Certainly,
eh?
sir. Certainly.
They'll be like, eh? Some of them, if you ask them something, they will become your friend because you make them look stupid. You don't insult them, you will not insult them. You just ask simple fundamental questions and they become very stupid. And so they go back and review and say, we went to one company, they ask other questions. And they will say, yeah, go on training. They'll go and send them for training the way you are training yourself. Say, okay, that's it. Jethro, your hand is up.
Yeah, yeah. Good evening, sir.
Sir,
Are
yes,
you a
sir.
senior,
Good evening,
you also
sir.
a senior advocate, Jethro? Okay. Adeba, hold on, let's hear Jethro. A senior
Good
advocate as well. Yes,
Okay,
Jethro.
good evening, sir.
evening, sir. My question is
Hello,
concerning.
hello. Good evening, sir. Can you hear
Jethro,
me?
Jethro, Jethro, go on. Adeba, just hold on.
Okay, so sir, I read up something some times ago on social media. I'm actually a HR professional, and that's why I'm curious to know what uh, what can be done. And so there was this employee in Switzerland just in 2020 when COVID-19 was ravaging the whole world and there was lockdown and all of that. So the employee was employed and initially was working in the office, and then when COVID-19 came, they were asked to go, and then he started working from home. Then after some months, the employee came back and said, that he is that the employer should pay part of his rent because he has been using his house as an office. So and then it became something that the employer, were doing, and then he went to court. I didn't actually know the conclusion or the judgment, but I just feel like, okay, let me bring it here now, so that maybe as a social engineer that you are, sir, maybe you could tell us the legal tools that could be used to at least look at the case, is it justifiable for employee to come back, because the contract was for him to be working in the office and then he started working from home. So is it justifiable is his case justifiable? Let me just put it that way.
You want to be smart, Abi? You want to consult a senior lawyer and then you want to use classroom, Abi?
No, no, no,
Uh,
sir.
no, no, no. You want to use class now to get legal advice free of charge. You're combining, you can't go like that. Better come to our chambers to give proper advice. Don't use classroom. Yeah, you just
No, no, sir. I think it's I feel like I've been looking for
anyway,
opportunity to
anyway,
actually ask
no,
this
no, no.
question.
That this is pretty straightforward. You know, the issue is that the question is that at the time that the employee were to go and working from home, what were the terms of working at home? We those things bargain? Was it that okay, work at home, we use your house to become you pay for using your house, and so there are always terms of working from home. So those terms, it means that if those terms turns out not to favor the employee, he has to come back to negotiating table because certainly there are terms of well, these are the terms. So he would have said no, I will not work. I will not work from home. It didn't favor me. Oh, I work from home upon X Y Z happening. That's all. So is the terms of at the time that is working on home and the terms that you guys agree on that bind on the employee. So if subsequently those who are not working, they can still come. That's why parties have the right to negotiate. You can always negotiate and amend the contract as frequent as possible. Yes, Adebo. Yeah,
Good evening, sir.
yes.
Sir,
You didn't raise up your hand, so
I
I wasn't seeing you.
yes, sir.
Go on.
Yes, sir. So, sir, my question is concerning the difference between the invitation to trade and an offer. For example, maybe a company, in terms of advertisements, if a company advertises a product offer and they state maybe the terms and condition that applies to that offer, and also telling you like the procedures in which you can gain that particular offer. Can we say that that advertisement is an offer or is still an invitation to trade?
So the general rule is that all advertisement are invitation to treat. That's what the general rule says. All advertisement. Once you say that I have advertised, they're just inviting you. That's why they can change. And so many things can change. It may turns out that when you want to go read, the thing will not be as advertised. So advertisement is just a way of calling on people. Let's come and do business. You're inviting the public. Let's come and do business. So it's not they're not offers themselves because it's when you now come you want to do the real business, you start negotiating the real terms outside of the terms of that advertisement. So the general rule speaking is that. So but when in addition to that advertisement, certain things are done that will suggest certainty, clarity as what it is, then moves from that advertisement to offers. And that was what happened in Cali. So in Cali and Carlos Mobile Company from there was advertisement, but because they now say that they deposited money, that shows that it moves from the act of just advertisement, but with the act of depositing money for any person that will be harm or will still be affected by that influenza. That was what made them to lose the case. But if they're not added other time, other all of those actions, if they're not taking further steps, just mere advertisement, then of course that would have been the you offers. So even if the advertisement for maybe scholarship, they will say scholarship, you must have this, you must have 2-1, you must have those advertisements. You may have all of those requirements and apply for that scholarship. But they might say, you know what, when it comes to this one, you may discover that your name will not come out. So just have it at the back of your mind that as general rule, once it's this in adverts, then the law first of all look at this is invitation to treat. It's not, they're not offers. So we need further further activities, further you know state of affairs to add to that advert to make it offers. They vary with the facts and circumstances of each case. Okay, I want to move into acceptance, but you guys are holding me back. Oh, question. You want to smart. Don't want me to. Um, you don't want me to do it. Should I? Yes, we have 7 minutes, so let's see how far we can go. Yes, acceptance as another element of contract. Yes, our speaker, read the first sentence.
An acceptance is a final expression by the offeree that he agrees to the terms of the offer as conveyed to him by the offerer.
Thank you so much. So you see that just as we're saying that in an offer has to be definite, acceptance also has to be definite. Final, final, final. Don't start adding something to it. I want to come party, but you with your coming party dress like this. Oh, I know I won't dress. I don't have the. Oh, you know. So it must be final. It must be unqualified. It must correspond. In fact, that is the most easy way to understand it. That acceptance must correspond to all the terms of the offer. All the terms of the offer. Remember, the offeror has made a definite statement. It's clear. Anybody can understand. This is what this person intended to be bounded on. So if you are not accepting and you don't introduce something that was outside the terms, that cannot be a valid acceptance. And that's what the law is at. Is what they call the mirror image rule. Mirror. Just as you stand, you dress up, you stand by mirror, by mirror, and then you reflect the way you dress up the mirror. That's how we're saying that acceptance, whether orally, whether in writing, whether by conduct, must correspond, not outside the terms of an offer. It must mirror the terms of an offer. So the mirror, the image here is the terms of that offer. So acceptance also must mirror the image, that is the image of the offer, the terms of the offer. Must be exact without any intention to further bargain. So, but if you add some things that were not in the offer, which to this the offeror would start thinking, oh, should we do this? Should we do that? Or should we not do that? And all of those, then it becomes invalid type of acceptance. It becomes invalid type of acceptance. This is straightforward. So it must correspond. If the offer say red biro, must be red biro. Don't accept the supply. I have 10, I have 5 red biro. I will supply 5 and supply 10 blue. Is that what the offer says? As simple as they are, the offer says supply 10 red biro. You accept. Yes, I will supply 5. Oh, in the stock, I have them in stock. I will supply 5. I will supply 5 blue. It didn't correspond with the terms. The other terms, yes, it's biro, but what about the color? It's missing. So now you are not giving opening another door again to for the offer to start thinking, okay, should I accept the blue or I should not accept the blue? So one example of invalid type of acceptance is a counter offer. A counter offer is when you do what? When you do what? You alter, you change, or you amend the terms of an offer when you are supposed to accept. It could be the way of price. Offer is made, your employment is 500,000 a month. You accept, and you are adding that plus a car. They should give official car or the military staff. Ah, or your office you have book. Is that the terms of an offer? No, that means a counter offer. And the effect of a counter offer is that it destroys completely that offer that was given to you. Once you counter it, you have destroyed it. That offer will never exist again. The life, it has been dead. So you cannot even change your mind. Say, okay, I've changed my mind. I want to go back to what you gave me before. La, it's too late. So as businessmen, when you are bargaining, an offer has been made, and accepting it, you now introduce something new. Note that at that moment, that's your amendment, new thing that you introduce, has cancelled that offer that the person made to you. So if that person was the offeror and you are the offeree, but because you have destroyed it, you are the one that is overall now. The person was offering who will accept or reject your offer. Now, so there's also the so is there any question on that? Counter offer is when you utter or amend the terms of the offer, and then of course the effect of it is that it destroys the original offer, and then that purported acceptance become a new offer. The offeror, the offeree, who can now accept or reject, right? Also, you note the issue of as also lawyers note when a contract has the clause subject to contract, where a clause has a clause when the contract has the clause subject to contract. So, because of time, I will ask you to go and read this that case. Go and read the case of UBA and Tejimola. We'll discuss this case in the subsequent class. Do you have any question? Learner colleagues, any question?
No,
I
sir.
did say you be at Tojimola, sir.
Yes, UBA is there on the slide. Can you see the slide?
Yes, I can.
So that last case there's a case of it's online. You can Google it.
It's online. Right, sir. Thank you, sir.
Okay, so yes, Adebayo Elijah, your hand is up.
Thank you, my honor.
Yes.
I would like to clarify since you mentioned that the counter offer it has already rendered the first offer invalid. For instance,
It destroyed completely. No more alive.
so for instance, okay, a company gave me an offer, say ₦1 million for my net, and I decide that they can do more. Let me accept, give them a counter offer of 1.2 million. So they said they can't do that. Can I say, oh yeah, let's go back to the 1 million? I
It's,
actually
it, it's too
like
late.
1 million.
It's,
I just they can take it, but they
ah,
said no.
it's too late.
So I can't say I will manage it like that, that I'm fine with the 1 million.
No. Once we're saying we want to go back to 1 million naira, it's you that's making that offer now, not the company again.
Okay. So I
Yes.
can't say I've accepted the previous offer.
No, you don't accept what is dead now. That one has been scattered pieces. They have been destroyed. No more existing. By the addition of 200,000. So you can't ask to go back to it again. So, but it's your own new statement now that becomes an offer.
Okay.
These guys, I'm suspecting you guys, you lawyers, is that you are using this class to get some legal advice. I'm suspecting this my learned colleagues. Please, you want legal advice, come to the office. Yeah, because I will appoint a chief whip here. Any lawyer that is trying to get legal advice from the class will pay a fine. Yes, if there's no further case for discussion, any case before the court, senior lawyer should move for adjournment so that the court will meet and sit another day.
Sir.
Yes.
Lord, in the absence of no addition of subtraction, I want the motion to have done the class together.
Okay, the same venue. The court will sit the same venue, the same time next week. Next week when you have to add the date to next week when.
Next Friday, same time.
Okay. Any objection From any lawyer, any objection from any counsel?
No, no objection, sir.
No objection.
No
Okay.
objection, sir.
No objection, sir.
We adopt the deal, sir.
Okay, we adopt the
No
date.
objection,
Okay.
sir.
Objection over, my lord.
Okay.
Thank you,
So
my lord.
the date stand. Yes. Thank you all, the colleagues.
Thank
Let's
you
call
very
it a
much,
day.
sir.
Yeah. All right. Thank you. Yeah. Bye bye.